Okay, hello everybody. So I think we're going to get started now. So welcome to the Georgetown Federalist Society's event. This event is co-sponsored by Georgetown Right to Life and the Knights of Columbus. So tonight's event is Revisiting Planned Parenthood versus Casey after RBG. Does abortion really advance women's equality? And our speaker is Erika Bachiochi. And later on, we'll have some questions, which will be moderated by Kerry, the president of Georgetown Right to Life. So you can send in your questions using the Q&A feature later on. So a little bit of information about Erika is a pro-life feminist legal scholar. She is also a fellow of the Ethics and Public Policy Center and a senior fellow at the Abigail Adams Institute. Erika received her BA from Middlebury College, her master's from Boston College, and her law degree from Boston University. She has published several law review articles, including Embodied Equality, Debunking Equality Protection Arguments for Abortion Rights, and a Putative Right in Search of Constitutional Justification, Understanding Planned Parenthood versus Casey's Equality Rationale and How it Undermines Women's Equality. Erika Bachiochi was also a visiting scholar at Harvard Law School in 2018. So I just want to thank you, Erika, for agreeing to speak at our event, and I want to thank you all for coming. And I just want to also remind everyone that, as always, the views presented at our events are the views of the speakers and not necessarily the views of the Federalist Society. So thank you, everyone, and I'll let you start, Erika.
Thank you so much, Francesca. It's good evening, everyone. It's really nice to be with you, albeit here on Zoom. I actually hadn't heard of an undergrad Fed Soc before, so it's a real pleasure. I do hope you love the law as much as the law chapters do, because I'm going to dive right in. So I'm going to share my screen here and bring up some slides. All right, so tonight I want to revisit with you Planned Parenthood versus Casey, the Supreme Court decision that in 1992 reaffirmed Roe v. Wade and is still the law of the land today. It is not Roe, but Casey and its undue burden standard that governs abortion law. And so it is Casey that we should seek to better understand as we think together about the future of abortion rights, especially with Justice Ginsburg's seat now vacant and a new, very different kind of judge primed to take her place. Now, Casey is an opinion that sounds in substantive due process, but was mostly decided on the basis of stare decisis, as I'll discuss tonight. But in my view, Casey is really an opinion concerned about women's equality, but I don't think it's been adequately critiqued from that perspective. Thus, Justice Ginsburg was not wrong when she described Casey as such in her fiery dissent in the late-term abortion case Gonzalez v. Carhart. Quote, "As Casey comprehended, at stake in cases challenging abortion restrictions is a woman's right to control is a woman's control over her own destiny." The accuracy of Ginsburg's description of Casey aside, however, I think Casey's view of women's equality is deeply troubling, as I'll spell out in this presentation. My remarks tonight draw heavily from a lengthy law review article I wrote for a symposium on the 14th Amendment and abortion a few years back, and Francesca mentioned the title. In the article, I argued that equality reasoning for abortion can be found throughout the joint opinion in Casey. Indeed, that women's equality is really the central interpretive concept. But as I have only a brief time with you tonight, I'm going to focus on the most consequential aspect of the Casey opinion, as regards reliance interests. So, by way of summary, at the outset here, I want to suggest that Casey reaffirmed Roe, not because the justices in Casey thought Roe was rightly decided as an original matter, as they tell us more than once in the opinion, but rather because the justices who wrote the joint opinion assumed that the country, over the intervening 19 years, had come to rely upon the right bestowed in Roe as a centerpiece of women's liberty and equality. And the justices just couldn't stand in the way, whatever the Constitution said or didn't say about the matter. One question among the many we might ask about this sort of judicial determination is the one I'll grapple with today. Whether our society's putative reliance on abortion has actually promoted women's equality. I think on the whole that it has not. In doubling down on Roe during a time of rapid cultural change, Casey put the weight of the court's authority on a particularly inhumane way of trying to secure women's equal status in society. And in my view, this has debilitated efforts to more authentically respond to women's disproportionate role in reproduction ever since. So with that brief introduction, let me now offer a fair bit of background on Casey and how the case was decided before I jump into the substance of my argument regarding women's equality. As some of you may know, Roe v. Wade was criticized almost universally in the legal academy after the decision was rendered in 1973. Even those in favor of abortion rights found fault with the privacy rationale in Roe, most famously pro-choice law professor John Hart Ely, who excoriated the decision the very year it was rendered in his singular commentary, The Wages of Crying Wolf. It's still, I'd add, probably the single best critique of the Roe opinion, and so really worth reading and rereading today if you have lots of interest in the subject. In the decades that followed this and other critiques, a cottage industry arose within the law journals in search of an alternative constitutional justification for the beleaguered right. With almost unanimity, that alternative was equal protection. First fully articulated in 1977 by UCLA law professor Kenneth Karnst. Karnst wrote, cases such as Eisenstadt, that's the contraception case the year before Roe v. Wade, and the pregnancy discrimination case Lafleur, all these can be seen as women's role cases. So viewed, they implicate the principle of equal citizenship, he wrote, for they involve some of the most important aspects of a woman's independence, her control over her own destiny. That's the same language we heard Ginsburg quoting from Casey. The abortion question was not merely a woman versus fetuses issue. It was also a feminist issue, an issue going to women's position in society in relation to men. Now, the Equal Protection Clause had been put to new use beginning in 1971 and in the decades that followed as the court began to strike down statutes and regulations it deemed to have arbitrarily discriminated on the basis of sex. Influential expositors of the law, most notably Ruth Bader Ginsburg, that advocate most responsible for the court's new turn on sex discrimination, latched on to Professor Karnst's equality rationale for abortion rights. And she writes about very explicitly quoting him and paraphrasing him in her law review articles with regard to this issue. She speaks a lot about equal citizenship, as we see in some of her dissents too from the Supreme Court. With Ginsburg's influence especially, equality reasoning became the prevailing means by which legal scholars and then advocates defended the Roe regime, even if the Roe opinion itself had few defenders. It's no surprise then that nearly 20 years after Roe, when the court sought to replant the right to abortion on more solid constitutional footing in Casey, or so they hoped, the justices had equality reasoning in mind. Now, as the nation awaited the Supreme Court's decision in Casey, many commentators suggested that the High Court was poised to overturn Roe. 12 years of Republican judicial appointments had altered the High Court's composition, and in 1983, Justice Sandra Day O'Connor had already announced her disfavor of the 1973 opinion in her dissent in the City of Akron, the Akron Center. In other words, the political and journalistic world has been anticipating the overturning of Roe for, well, decades. But rather than overturn Roe, Casey, of course, reaffirmed Roe, but altered the test under which state regulations of abortion would be reviewed. In an opinion signed jointly by Justices O'Connor, Kennedy, and Souter, the court held that the trimester framework Roe had erected, the strict level of scrutiny Roe had required, and the cases subsequent to Roe interpreting the same had all too little acknowledged Roe's own express regard for the state's, quote, important and legitimate interest in potential life. The joint opinion thus inserted in place of Roe's framework a revised version of the undue burden standard O'Connor had previewed in her dissent in Akron 10 years prior. The undue burden standard was, of course, the constitutional standard at issue in the most recent abortion case litigated at the Supreme Court, June Medical v. Rousseau. Now, curiously, the Casey court suggested at several different points in the joint opinion that even as it reaffirmed the central holding in Roe, it was not able to endorse the 1973 decision due to Roe's underappreciation of the state's, quote, profound interest in fetal life. Indeed, the joint opinion suggests that as an original matter, the justices signing on to that opinion in Casey would likely have decided Roe differently. Still, even if the Casey troika or even a single justice among the three thought that Roe was wrong as a matter of constitutional law in 1973, in 1992, they reaffirmed the decision, writing that a terrible price would be paid were the court to reverse course now. The court reasoned that the potentially erroneous decision 19 years prior had created certain reliance interests in the decision, and thus the right to abortion had become a rule of law and a component of liberty we cannot now renounce. That's a quote. The court declared that the doctrine of stare decisis, wherein the court stands by a prior decision even if it is wrong, makes this so. Now, many have ably critiqued the court's use of stare decisis in Casey, most notably the late Justice Scalia in his Casey dissent, an eminent constitutional law professor and popular FedSoc speaker, Michael Stokes Paulson. But when the plurality declared that a terrible price would be paid for overruling Roe, both Scalia and Paulson understand the court to be concerned primarily with the legitimacy and integrity of the court itself. And this basic critique of Casey's stare decisis reasoning is mainly what you'll hear from conservative legal thinkers on the whole, and what we always hear debated during judicial confirmation hearings. So get ready. So though it's probably not so prudent to argue against these two constitutional giants, I think the text of the joint opinion indicates that the court was actually concerned primarily with something else: the impact a reversal would have had upon women's enhanced status in society. Now, this is not to say that the voiced concern for the court's legitimacy and institutional integrity expressed in the Casey decision was not at all important to the justices and the plurality, for surely the space afforded and the sheer energy manifest in that part of the opinion revealed that it was. It is to say, however, that by its own terms, Casey indicates that women's constitutionally protected, quote, liberty to access abortion to, quote, participate equally in the, quote, economic and social developments of the nation is the key concept undergirding the controversial reaffirmation, which we will get to directly here very soon. But perhaps the court's concern about its own institutional integrity and legitimacy may have gone hand in hand with worries about how the court would have been perceived had it upended the constitutional right to abortion, what had become, over the intervening 19 years, the sine qua non of the modern day women's movement. So my point here is not to disturb those other critiques of the stare decisis or institutional integrity arguments. My point here is only that critics of Casey have not taken the underlying concerns about women's equality seriously enough. If I'm correct, it would behoove those seeking to revisit Casey, and so Roe, to better scrutinize the joint opinion put in abortion as an important element of women's equality. This may seem counterintuitive, as many critical of Roe and its progeny, myself included, regard the weight of scientific evidence concerning the humanity of the unborn child to be indisputable, and the philosophical attempts at distinguishing the rights-bearing human person unconvincing, and so would seek to urge the court to reconsider on those grounds, as amici have done for the last several decades. But without a wholesale abandonment of the court's current jurisprudence, likely possible only through a radical rightward shift that doesn't heed the Chief Justice's desire for stability, Casey will have to be undermined according to its own terms, ones in which women's liberty and indeed women's equality are paramount. And of course, these are the main terms of the political movement for abortion rights as well. Now, what I'm not suggesting is that the joint opinion in Casey was at all as forthright as Justice Harry Blackmun's concurrence in Casey or Justice Paul Stevens' separate concurrence, in which they both suggest that the court ought to alter the constitutional basis for protecting abortion rights from due process to equal protection. This is, of course, what Ginsburg and other scholars had argued for in the academic literature. But the joint opinion's use of stare decisis, in particular its discussion of reliance interest, does nearly the same work, at least rhetorically, without abandoning the due process framework. Casey thus ought to be critiqued from that more substantive vantage point. Now, I spend a lot of time setting all this up with recourse to the various parts of the Casey opinion in my article, and even push back a bit on the prevalent idea among judicial conservatives that stare decisis is the only reason, for the reaffirmation of Roe. But for the sake of brevity tonight, let's look at the oft-quoted Casey text, in which the plurality maintains that individuals and even society as a whole have reliance interests in Roe. Now, parenthetically, especially for those who aren't law students yet, potentially, reliance interests in the law are usually at play in commercial or property disputes, where a change in the terms of contract or other legal interests would cause serious inequity to those who have relied upon it, perhaps by prior commitment of investment or something like that. So it's a bit of a creative kind of sociological observation that the court makes there. Okay, so let's jump into the key text that many of you have probably heard potentially many times before. Quote, "For 2 decades of economic and social developments, people have organized intimate relationships and made choices that define their views of themselves and their places in society in reliance on the availability of abortion in the event that contraception should fail. The ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives." Now, there are 2 claims being made here. One as regards the interplay of abortion and contraception. The other regards women's equal participation in economic and social life. Obviously, these are themselves interconnected, but I'm going to look at each in turn to ask whether reliance upon the right bestowed in Roe was as good for women's equality as Casey presumes. Now, as a descriptive account, I think the first concerning intimate relationships is quite accurate. Again, from 1973 onward, people had organized intimate relationships and made choices that defined their views of themselves in reliance on the availability of abortion in the event that contraception should fail. This sounds like an apt description of the sexual revolution. Reliance upon abortion is in fact very much at work in contexts where abortion is readily available, as it had been made in Roe. But the reliance effect of readily available abortion, if studied over time, is more far-reaching than the court here presumes. Indeed, the reliance upon abortion is less notable as a remedy for contraceptive failure in individual cases, which is the court's simplistic assumption. Easy abortion access, as has been granted in Roe, is far more notable, according to economists, for its moral hazard effect, for inspiring a large-scale society-wide increase in sexual risk-taking on the part of sexual actors. That is, rather than merely offer a practical fail-safe in the event of a contraceptive failure, as the Casey court suggests, easy abortion access has actually been shown to disincentivize contraceptive use and thus lead to more abortion overall, as we saw especially in the 1970s and 80s. Dr. Alan Guttmacher, then president of Planned Parenthood, was prescient in this regard when in 1968 he said, "When an abortion is easily obtainable, contraception is neither actively nor diligently used." So let's look at this moral hazard effect a bit more closely. As Wellesley College economist Philip Levine explains in his book, Sex and Consequences, quote, "The problem with the view that abortion impacts only the individual or the couple is that abortion decisions may also lead to something that economists call an externality, in which the behavior of one individual has implications for the well-being of others. And that externality may be positive or negative for society." So how does easy access to abortion produce this externality? Well, as analogized to insurance, abortion offers complete protection against the risk of childbearing. Complete protection against risk, economists tell us, tends to lead to riskier behavior. relatively easy access to abortion then working as a kind of secondary insurance to the primary insurance of contraception has been shown to change sexual actors' behavior in favor of greater sexual risk-taking, thus increasing, as Levine says, the likelihood of abortion being needed. Here's Richard Posner in 1994 describing the sort of unintended consequences here. If abortion is cheap, intercourse will be more frequent and may generate more unwanted pregnancies, not all of which will be aborted. This should help us to understand the combination of cheap contraceptives, frequent abortions, and yet a high rate of unwanted births in our society. Notably, the rate of non-marital births has increased most significantly over the last half century among poor women, for whom the attitudinal decoupling of sex and childbearing and marriage ushered in by this new sexual insurance scheme has been most acute. This does not sound as though women on the whole are having a much easier time, quote, controlling their reproductive lives. Now, were abortion less readily accessible or more costly, economists suggest that contraceptive use and greater avoidance of sexual activity would actually increase, and that the rate of unintended pregnancy, abortion, and even single motherhood would likely decrease, though never to a vanishing point, of course. So I put here on the slide several different studies over the years, and I'm going to draw out the green one here because it's kind of the most in the most sort of summary form here, especially what I've bolded. These economic theories detailed over the course of the last couple decades seem perhaps to be playing out in our day. Recent data has shown a significant decrease in the abortion rate beginning in the mid-1990s. Pro-lifers have credited legislative restrictions of abortion at the state level in the decades following Casey, which again, as I said, kind of tightened up on Roe, making abortion a bit less available, at least in some states, definitely not in others. Pro-choicers have credited increased contraceptive use. While perhaps both are true, modest restrictions on abortion have made abortion a bit more costly and therefore have created incentives toward more responsible sexual activity, including more contraceptive use and greater avoidance of sexual intercourse, both of which have been reported recently. So the descriptively accurate account of reliance upon abortion in intimate relationships is entirely question-begging as a prescriptive matter. That is, could such a reordering of thinking around abortion, such a reliance upon abortion, have actually had a distortive, detrimental effect upon society, upon women? One could argue that in practice, the sexual insurance policy putatively taken out to insure both sexes against childbearing in reality insures primarily men, leaving women, especially poor women, worse off. Not only have sexual norms shifted away from the higher commitment sex that research continues to indicate is preferred by most women, but the increased rate of unexpected pregnancy, non-marital births, and abortion that accompanied the new sexual ethic, especially right after Roe, disproportionately impact women. The now common mentality that sex has no consequences and thus entails no responsibilities often leaves women alone with their pregnancies, to procure abortions or rear their children on their own, both of which portend various harms in themselves, especially among the poor, who have by far the highest rate of both abortion and non-marital childbearing. We'll return to this point a bit later. Now, of course, the court was not only interested in how people have organized intimate relationships. The court was also concerned with people's places in society, and in particular, the place of women in society. Again, the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. The court cites as authority for this proposition both a page and a footnote from a book entitled Abortion and Women's Choice, published in 1990 by Professor Rosalind Pollock-Pachetsky. The page of the book referenced by the Casey Court falls in a chapter that discusses the correlation between women's decreased rates of fertility with women's increased rates of education and employment, especially in the decades prior to Roe, during and after the Second World War. Such a correlation is unsurprising and uncontroversial, and the author is good to point out that the causal relationship between the two is uncertain. That is, do women tend to work more when they have fewer children, or do women tend to have fewer children when they work more? But importantly, the Casey Court is not simply making a claim about women's decreased rates of fertility. It is making a claim specifically about abortion. That is, in declaring in a case concerning abortion that women's participation in social and economic life is facilitated by their ability to control their reproductive lives, the court is making the much more specific claim that abortion is necessary for such participation. But Bachiochi does not say this. Instead, she hypothesizes, notes the complexity of the data she is discussing, and even that such data is not subject to generalization, but generalizes exactly what the court does. And so in grounding its reaffirmation of a decision it thinks was likely wrongly decided as an original matter, the Casey Court is relying on a generalization unsupported by the very reference it cites. That is, even if lower fertility rates do lead to higher rates of education and employment or vice versa, the court does not offer any evidence that abortion, rather than, for instance, fertility regulation of various kinds, is specifically correlated with higher rates of education and employment. To date, we have no such evidence, despite anecdotal accounts in recent amicus briefs proclaiming things like, "I'm an attorney because I had an abortion." If you doubt this, go find reputed economist Golden and Katz 2002 paper in the Journal of Political Economy. Now, former Chief Justice Rehnquist thankfully called out the court in this regard in his Casey dissent. Surely it is dubious to suggest that women have reached their places in society in reliance upon Roe, rather than as a result of their determination to obtain higher education and compete with men in the job market, and of society's increasing recognition of their ability to fill positions that were previously thought to be reserved only for men. One can point more readily to both state and congressional initiatives in support of women's equal opportunity in the workplace, as well as the many anti-discrimination cases won at the High Court since the 1970s. Dubious, yes, Justice Rehnquist. A bit insulting, too. After all, putting aside the court's lack of evidence for its broad claim, and even assuming, just for the sake of argument, that women's equal participation in economic and social life is an appropriate proxy for gender equality, an assumption I would dispute, the joint opinion's further assumption that abortion is necessary for such equality could be construed instead as deeply misogynist. As I wrote about at length a few years back, the equality argument for abortion rights rests upon a peculiar 1970s feminist philosophy that reduces sexual equality to sameness, setting up the male body as the norm. As many now know, this disembodied theory of equality marked a dramatic departure from prior generations of women's rights advocates, Mary Wollstonecraft in the late 18th century and the 19th century suffragists no less, who instead insisted that women's unique capacity to bear children did not undermine their fundamental equality with men. For the suffragist, abortion was evidence of women's ongoing oppression, and many, like Elizabeth Cady Stanton, presumed the repugnant practice would be abolished by the elevation, education, and enfranchisement of women. The feminists of the late 19th century fought for suffrage in part to enable women the political means to work toward a more humane society that would be more hospitable to both women and their vulnerable children, both born and those still developing in their mother's wombs, as the suffragists themselves said. Indeed, it was not until the 1970s that agitating for abortion rights would take center stage in women's rights advocacy. When Betty Friedan first penned the original statement of purpose for the National Organization for Women in 1966, it did not include abortion at all. Since we're on Zoom, I put the link here. I invite you to read it. Well, hopefully not right now, but later. I think it is something that many, many people could coalesce behind today. But the following year now changed course, and in 1968 included abortion rights in its 8-point National Women's Rights Program. Abortion has, of course, remained the sine qua non of the movement ever since. The equality argument for abortion suggests that just as men can physiologically avoid the reproductive potential of sexual intercourse, men's bodies do not experience the consequences of their fertility within them, so too should women be enabled. As eminent law professor Lawrence Tribe writes, while men retain the right to sexual and reproductive autonomy, restrictions on abortion deny that autonomy to women. But it is not abortion restrictions that deny sexual and reproductive autonomy to women. The state of pregnancy itself exhibits the embodied reality that when pregnant, a woman is not physically autonomous. She is carrying a new, albeit dependent and vulnerable human being within her. Thus, unlike a man who has fathered a child, a pregnant woman cannot simply walk away. Note, to approach the desired autonomy of the child-abandoning man, a pregnant woman must engage in a life-destroying act. Sexual equality is sought not by demanding that men meet women at a high standard of reciprocity, mutual responsibility, and care, as Wollstonecraft and the 19th century women's rights advocates had argued. Rather, as men had wielded the common law right of dominion over their wives, women would now seek a similar right to the ultimate sort of dominion over their unborn children. Relying on abortion to facilitate gender equality then is seeking a kind of faux equality for women by way of imitation of men, and not very good men, I might add. Instead of insisting upon cultural acceptance of the distinctive reproductive capacity of women and cultural respect and support for the caregiving women still disproportionately undertake, abortion rights feminism seeks to facilitate sexual equality through legitimating violence against nascent dependent children, to whom their mothers and their fathers and society at large properly owe duties of care. Indeed, the Casey plurality offers no argument that abortion is an act worth relying upon for the good of women's equality. As in its contraception discussion, it merely assumes so. But given the violent nature of the abortion procedure committed against an innocent, albeit nascent child, that assumption on the part of the plurality is reminiscent of the sort made of prior social evils that our nation also relied upon for positive social goods. In this vein, Michael Stokes Paulson provocatively writes, for 2 decades of economic and social developments in vast regions of the nation, people organized personal relationships and defined their views of themselves and their places in society in reliance on the legal regime of segregation. The same too can be said for the putative property rights the court notoriously upheld via the Due Process Clause in Dred Scott. The entire Southern economic system had relied on slavery for its, quote, economic and social development. That they did so rely does not in itself speak to the reasonableness, rightness, or constitutional bearing of the reliance claim. Just as we can say that a flourishing economy is a social good, but that relying on slaves to furnish such an economy is a great social evil, so too can we say that women's participation in economic and social life is a social good, but that endowing women with a high court license to end the lives of their unborn children is, I would argue, echoing Wollstonecraft and the suffragists, a great social evil. As Rehnquist wrote in his Casey dissent regarding the indeterminate nature of a reliance interest, the simple fact that a generation or more had grown used to these major decisions, there he's referring to both Lochner and Plessy, did not prevent the court from correcting its errors in those cases, nor should it prevent us from correctly interpreting the Constitution here. Further, the same sort of critique I offer regarding the relationship between contraception and abortion is again available here. Does not society's reliance upon abortion for women's equality beg the very question of whether that reliance actually advances women's equality? For I think a very strong argument can be made that the constitutional right to abortion has actually hindered the authentic equality of women by promoting cultural hostility toward pregnancy and motherhood and fatherhood too, and so derailing the necessary cultural respect and accommodation they deserve. The 1960s and early 70s were decades awash in new questions that emerged with the revolutionary release of the birth control pill, alongside women's increased social status and the unprecedented entry of mothers of young children into the workforce. As the then distinct women's movement and sexual revolution moved at pace alongside one another, but not yet together, society had before it a newly emergent set of yet unforeseen and entangled questions. Number one, how to enable women to participate more fully in the public sphere. Number two, how to manage the significant technology shock created by the advent of the pill, effective, but importantly, not 100% so. And number three, how to maintain utmost societal concern for the perennial need to care for dependent children, who heretofore had been the primary responsibility of their mother. The Supreme Court in 1973 chose one definitive route, short-circuiting impassioned debates going on across the country in state after state, and thereby frustrating not only a better compromise among contending perspectives, it also thwarted more humane and creative cultural responses to the asymmetries that naturally exist and socially persist because of women's disproportionate role in human reproduction. The court in 1992 then doubled down on this particular response, explicitly acknowledging that over the course of nearly 2 decades, the country and its actors had come to rely upon abortion for women's equal participation in public life. Indeed, it may be that when the Casey court suggested that, quote, an entire generation has come of age free to assume Roe's concept of liberty in defining the capacity of women to act in society, it is again descriptively accurate. When the Casey court doubled down on the constitutional right to abortion, employers and other public institutions remained free to be unchanged by women's participation in them. Through women's legal right to abort their nascent children to participate in the market economy, women have learned to model themselves after the unencumbered men with whom they seek to compete. But what if instead, smart and talented women and men, like the ones presumably listening to me tonight, led our profit-driven culture to understand that most working persons are or ought to be deeply encumbered by their prior obligations to their families and to the dependent and vulnerable at large. It's no surprise, given the centrality of abortion rights in the feminist movement today, that work-family balance remains such a pressing issue facing women, and that it is women's status as mothers, not their status as women, that still causes the greatest inequities socially and professionally, despite remarkable gains to women overall. The idea that abortion rights offers a solution to that problem, or as I am arguing, has exacerbated the same, is a question ripe for serious debate within the women's movement itself. It is a debate the Supreme Court has forestalled with its intemperate abortion rights jurisprudence, to the great detriment especially of the poorest of women. Georgetown law professor Robin West, who is a leading pro-choice feminist thinker on these issues, has similarly suggested an inherent, quote, tension exists between the constitutional right to abortion and a legislative agenda that better values caregiving. Parenting, West insightfully writes, has merely become an expensive consumer choice. Quote, by giving pregnant women the choice to opt out of parenting by purchasing an abortion, we render parenting a market commodity. The right to an abortion gives women a right not to be a caregiver, but at the cost of rhetorically making the difficulties of caregiving all the harder to publicly share should she opt for it. For privileged women, this is not such a terrible trade-off, West says. But the woman only marginally capable of supporting even herself, however, faces a choice between parenting and severe impoverishment on the one hand and foregoing children on the other. But without Roe and with Ruth Bader Ginsburg's commendable wins in sex discrimination cases in the 1970s, workplaces would have had to adjust much more quickly to encumbered women and duly encumbered men, and so to the demands of the family more generally. The legislature was designed for the sort of pull and tug that could have occurred between various feminist, business, family, and social organizations, much like what happened in Western Europe after the sexual revolution. There, as Harvard Law professor Mary Ann Glendon revealed in her book Abortion and Divorce in Western Law, Europe saw a far more limited abortion allowance with strong statements and policies in support of caregiving. And I should note, they had none of the kind of vitriolic abortion debate that we've had for the last several decades. Though the United States would likely extol and support caregiving differently than Western Europe has, our penchant for free markets and subsidiarity, it surely would have been a priority much sooner without the reliance on abortion the Casey Court so boldly affirms. As I wrote a couple of weeks ago in a widely read article at Politico, when we belittle the moral status of the unborn child, treating the nascent human being in a near half-century of Supreme Court case law as, quote, potential life, or in academic and popular arguments as something parasitic upon the pregnant woman, we ought not be surprised when our workplaces and other cultural institutions treat dependent human beings that way too. If pregnancy continues to be likened to any other lifestyle choice, or worse, a disability in a Hobbesian contest with wombless men, pregnant women and caregiving parents will never receive the cultural support they need. And so, if the so-called gender revolution has stalled, as some feminists claim it has, elevating women in the workplace without simultaneously elevating the culturally essential work mothers and fathers do in the home, then I do believe that constitutionalizing the right to abortion shares a good deal of the blame. Now, it would surely be difficult for an older generation of feminists to imagine a women's movement without Roe and Casey. These feminists remember a time when women were regarded as designed solely for domestic life, when women's opinions were undervalued, and when mothers were seen as more capable and essential to their children's upbringings than were fathers. For these older feminists, restrictions upon abortion betray precisely that vision of women, one which unfairly confines women solely to maternity, with no respect for their contributions beyond. This 1970s feminist fear is, I think, what the Casey plurality is responding to. But for those of us who grew up with the Ginsburg's gains of the 1970s securely in place, there is no question that women are as capable of educational and professional achievement as men. The questions have now become why the essential work of caring for dependents, still undertaken disproportionately by women, is not as esteemed and accommodated as it should be, and why poor women continue to be bereft of the paternal support both they and their children so heartily need. It seems to me that these are the questions a renewed women's movement must work to address, and rethinking our reliance on abortion would be a good place to start. Thank you.
Thank you so much, Ms. Bachiochi. So now we'd like to move into the question and answer part of this presentation. If you are attending, please feel free to continue to ask us questions through the Q&A section on the bottom right of your screen, and we will field those as they come in. All right, to begin, Ms. Bachiochi, I was wondering if you could address the question of, is it possible to be both pro-life and a feminist?
Well, I hope that my presentation just addressed that question. Clearly, I think it is, and I actually think that it's more in keeping with the original kind of vision of women's rights that was put forth most brilliantly and by Mary Wollstonecraft in the late 18th century in her Vindication of the Rights of Woman. And I should just say just a bit about my background, maybe that would elucidate it too, is that I actually was one of the leaders of the Women's Center in the 1990s, dating myself, of course, at Middlebury College. And I was a women's studies student and a kind of a big pro-choice feminist. And I actually was in Washington, D.C. one semester and was reading I was at American University doing Washington semester. I don't know if they still have that, because I was very interested in public law and in politics. And so I was reading the cases of constitutional law for the first time, and I read Marianne Glendon's book, Rights Talk. And it really kind of opened, I guess you could say it opened my heart or my mind to the pro-life feminist position. She wasn't writing, the book is not, she herself is a pro-life feminist, Marianne Glendon. The book was not written in order to in any way kind of prop up this position, but she just made me think about what it means to give kind of, as she said, give a woman her autonomy and then kind of leave her alone with that, rather than surrounding a woman with a community and, you know, a man to help care for that child, or at least to have, you know, the father of that child be there and be supportive of offering that child up for adoption to the many families who are very willing and able to adopt. So I actually, I've written a lengthy intellectual history on women's rights that is coming out in 2021, wish it were here now, where I think that I really show very clearly that the pro-life feminist position has a very lengthy historical pedigree, and not because of, it's not to sort of, you know, just quote, you know, from suffragists or something like that. It's a real philosophical book, and also looking at sort of the way in which women's rights advocates responded to the asymmetry, the reproductive asymmetry between men and women. I think, and this is the last thing I'll say, but I think there's, you know, throughout the feminist movement, especially in the 1980s, you saw sort of discussions and debates among sort of sameness feminists and difference feminists. And I think what's missing from that is just to see that there's a real asymmetry between men and women when it comes to sex. And so women are really unequal in sex because of the consequences are obviously much more serious for women. And so what's the way that women's rights advocates have responded to that asymmetry throughout sort of, you know, from the mid 19th century when the women's movement kicked things off? And I think you'll see that in the early history, you see women actually calling men to be more present. So not only to be more present and engaged in the life of the family, but also, you know, they wanted what they called voluntary motherhood, which was absolutely not abortion, and it wasn't even actually contraception, but it was the ability to say no to sex, because men at that point had power over women to you know, to, especially their wives, to make them engage in sex. And so what they saw is that abortion would just liberate men to take more advantage of women. And I think, I mean, you look at Me Too, there's so much evidence that I think that that's really come to pass a little bit more than we want to admit, perhaps.
Yeah, absolutely. Thank you for your answer. We have a question from Carlos Rueda, who's a freshman at Georgetown. He says, how would you address someone that says the original feminist movement has outdated ideas?
Yeah, so I actually think that there's a real move. So if you look at a lot of care feminists, so it's funny because for anybody who's spent any time in women's studies departments or reading any feminist literature, which I have been doing for the last, you know, 2 decades, you see that there's a lot of different sorts of feminists. And there's, you know, those I would call autonomy feminists, who are more sort of liberal feminists who, you know, as many know, you know, sort of want to see women sort of, you know, be equal to men and more sort of like men, like take on the accomplishments and the success and all of that of men. But then there's care feminists, and also called maybe difference feminists, who, you know, take very seriously the care work that women have disproportionately done historically, and that women still do, either by choice, by necessity in places where, you know, they've been either abandoned by men or, you know, all sorts of other reasons. And so I think that there's a real move in the feminist literature to really take caregiving seriously and to expect more from men, and to expect men to take seriously their roles and their contribution as fathers, We've seen so much literature about how important the contribution of fathers is to children's lives. And so, I mean, to me, that is certainly, you know, an answer here is for men and women, when they engage in sex, to take seriously that what scientifically and biologically is happening if should the woman become pregnant is that they both become a mother and a father to that very, very young human being. And so that they both have responsibilities and duties of care. And of course, that adoption is always a very good option. But as I was saying that, you know, to tighten up on abortion some, you know, you're not going to see in the states where you've seen abortion restrictions tighten up, you see less abortion. You see people taking more seriously the consequences of sex. And I think that that's a good thing overall. It's good for women who, you know, want to see more high commitment, want to have more high commitment sex than men do in terms of the literature and statistically. Of course, there are exceptions always. So I think that these are very ideas that are coming back around, you could say. Thanks for the question.
Another question, what would you say drives the belief that women should partake in the same exact way as men do in the workforce via abortion, rather than recognizing the differences between the two?
Yeah, so I think, so there's all sorts of things. I mean, I think what I would say is that the very beginning of the women's movement in the 19th century and up through, and now you see, you know, some who hold these views was really had Mary Wollstonecraft as sort of, you would say, the mother of that movement, where there was a recognition of sexual asymmetry, but a belief that women ought to have equal rights to participate in education, the workplace, the professions, to contribute to the public square as much as men had full responsibilities and duties to engage in the public sphere. When you see John Stuart Mill come around, and I think there's lots of good in his small book, The Subjection of Women, but there is this sense that you know, equality is a kind of a strict equality, and I think that so what you see is you know, instead of asking men to sort of join women in doing you know, all of the whole panoply of potential things in life, which is participation in the public and professions and the care of children and all of that, there's this imitative effort to think that success in the workplace, money making, consumerism, those kinds of things, kind of the market, going kind of what I would say is, you know, entering the market on the same basis of men instead of critiquing the market and critiquing the market forces. That really is what the much earlier women's rights movement was trying to do, was seeing that consumerism and kind of a market mentality that just viewed sort of success out in the world as success in all of life was something that could really encroach upon the goods of the family, the goods of human relationships, the goods of friendships and community and you know, charity and caring for the poor and building communities everywhere. So I think that there's been a real loss there. But I think that that's where it comes from. And of course, abortion just adds to that by basically, you know, making women unpregnant, you know, so that they can be more like men, rather than asking all of society to see the real importance of caregiving as a priority, as a central priority in human life.
Absolutely. Another question asked anonymously is, how should we conceive gender equality in an age when this concept is largely framed by equal pay?
That's a great question. Yeah, so I think that it's a hard one, but I think, you know, the way that Mary Wollstonecraft, and she's really my teacher on a lot of this, would say that, you know, men and women are equal insofar as they both have the capacity, the human capacity through their intellect and their will to develop excellence in all they do. And so that really, rather than seeing pay, like a paycheck and how much I make, I mean, it really, I hope that people see that that's a bit superficial. You know, obviously every person needs to have the basics of life, and human flourishing does definitely depend on socioeconomic well-being. There's no question about that. But to some extent, you know, that really, you know, the paycheck shouldn't be the way that we think of people's equality clearly, because to say that the poor would be unequal to rich would be absurd. But I think that idea of seeking excellence in all we do, and that it's not that we all find excellence in equal ways. I mean, clearly there are different people who have excellences in all sorts of different ways, whether it's in their professional work, as athletes, as musicians, in their patience and other virtues, but that we all have the capacity to improve. And that's where she saw our moral equality, was in that capacity that human beings have to improve. And so that we all ought to be kind of helping each other in that way to improve. And so for her, she saw the work that was done in the family by both men and women as being really the most essential work there is, because that's where character is built in both children, but also in parents, to then come out into the public sphere and have some good character. Wouldn't it be nice if we had leaders with some good character for once, And I think it's only by looking at that kind of equality, the equality to sort of strive for excellence that we all have, rather than money or success, is the only way we're going to find good leaders. Again, otherwise we're going to be left with these kind of bankrupt characters leading our nation from all different sides of the political spectrum.
Mm-hmm. This is slightly tangential to your presentation, but I think related, and it's a question I've got before. Many pro-choice individuals have brought up, is the question of men getting vasectomies. And so do you think that, similar to abortion, this also would impede the true equality of dignity of women and men?
Yeah, so I mean, I think that it's not a question I've ever really gotten. I mean, I think that sharing the burden, I guess you would say, people have asked me for sure about male birth control. And I think, the best kind of male birth control is self-mastery, is men recognizing that there are so many asymmetries in sex. So there's the obvious one we've been talking about, which is reproduction. There's the asymmetry there, but there's other asymmetries in sex. I mentioned that women in studies that we see in both quantitative and qualitative studies say that they're interested in much higher commitment sex than men are. So if men really cared about women, they would master themselves and give more to relationships before they expected sex. We also see asymmetries, to get maybe a little, but we see asymmetries in the sex act itself, that men come to orgasm much more quickly, and women it takes a lot longer. So that men require self-mastery to really love women. To love being with women, really loving them, instead of just wanting intercourse immediately and with no sense of the consequences for women, the women that they ought to love. And so I think that a real key is for women to expect more from men rather than just giving them their bodies. To hold out requires men to be better men, and I think that to look at what the consequences of our sex are, the obvious consequence. But then to look at those other kinds of consequences, the emotional consequences, and the way that it really binds us to one another. It doesn't, shouldn't, I think, be like a recreational sport that only hurts women. So I think that that's the way that men can sort of equalize, the asymmetries, is through really mastering themselves, mastering their sexual desires for the good of women, for the good of the woman they love.
Thank you. It's a bit of a longer question. It seems as if the consequences of sex are easily overlooked and undermined due to contraceptives, but also because of how popular and normalized sex has become. Given that cultural climate, is it a matter of trying to reverse such mainstream ideas and norms? If so, would that even be possible? And if not, what would you prescribe to such an environment?
Mm-hmm. Yeah, of course, when the toothpaste is out of the tube, you wonder, is there anything you can do? And I think, there are there are movements, you hear slow sex and things like that. And I do think that it would really be, if we can have, we don't have to have a national conversation about sex. That might be a little awkward, especially with certain people in the White House. But I think if, there is a way in which, and this may be hard for real, abortion advocates to understand. But I think that if we did tighten up on sex, we start to see, when we start to realize the consequences of sex are more serious, right? And so there's no question that the law is educative, right? It has this pedagogical attribute. It's just part of what law does. I mean, that's why we have laws against murder and laws that prohibit littering and that prohibit polluting and that type of things. I mean, we want to educate the public to do the right thing. Obviously, there are consequences to those too, but because we think there are certain social goods. And so I think when you have a real, when you have an abortion license, there's no question that it makes people, think that abortion is an okay thing, and therefore it ends up being this backstop, and so increases sexual risk taking, as I talked about. And so I think if you, again, tighten up on abortion and say, let's have a national conversation about this, or actually let's have a state-by-state conversation, which I think would be much better, then we can start to see, what are the good things that could come out of not being able to, go right to abortion, but that would require men and women to think more seriously when they engage in sex. And I think you hopefully, especially in a time when women have reached such high heights in terms of their public influence, education, and all of that, there's a time when women could really start demanding men, more from men, and hopefully that wouldn't just drive men to sex robots. I suppose that's possible, but I think there are a lot of good men out there who would like to see this sort of shift too, where relationships become primary instead of just casual sex, which I don't think. I mean, there's reams and reams and reams of anecdotal, but then also quantitative evidence showing that women just don't like casual sex. Sure, yes, there are alpha women out there for whom this is an exception, who are exceptions, but for the most part, that women really don't want casual sex, that they really want to have a commitment before they engage in that kind of act.
Thank you. I have one final question that I was hoping you could address. So what recommendations do you have for us as college students? None of us are legal scholars. Some of us are interested in law, but some of us are not. What recommendations would you have for us seeking to really honor the dignity of women around us and seeking to build up a culture of life?
Yeah, I think it's a good question. I mean, if you're interested in law, there's so much to read, and it's actually a really exciting time in the law. I mean, not only because of Judge Amy Coney Barrett, who I think will be an exceptional justice and a role model for kind of a different kind of woman than what we've seen before, but because there's a lot of movement in constitutional law and constitutional law theories. It's just an exciting time, I think, to be in my field in particular. So I think just educating yourself, finding reading. Happy to have you email me, and I'll send reading lists of books that have really changed my way of thinking and helped to form me, I think, intellectually. But I think too, to really, I think it's to celebrate women who are standing outside the kind of the casual sex scene is, I think, always a good thing, to promote kind of dating, slow sex, and that type of thing. I think the other thing I would say is that it's really, really, really important for young people's voice to be heard, especially both on the pro-life and pro-choice side, that women who are facing unexpected pregnancy have immense support, both in their decision making, but just around caring for a child, adoption. Those kinds of things, and that we really call men to the task. I think that's really important as well.
Thank you so much.
Okay, so I think that was the final question. Is there anything else you'd like to say, Erika?
No, I'm sure that many of you are jumping off to go see the vice presidential debate, which I expect to be much better than the last debate, in which no one could get a word in edgewise. Obviously, that was kind of embarrassing. So yes, if we want to end early, so people can go see that, happy to have you do so. And please feel free to contact me via email. I prefer not, emails where I'm yelled at and called names, but I really do like engaging these questions. As I said before, I'm was on the other side of the issue for a long, long time. So I've thought a lot about this, and I'm happy to engage those kinds of back and forth.
Well, thank you so much for coming here and speaking at our event, and thank you all for watching. And we'll be having another event next week, Wednesday at 8 p.m. if anyone, so we hope to see many of you there. So thank you everyone and have a good night.
Thanks. Bye-bye.